Welcome to S&C Sidebar, where we talk with our different litigation partners about some of the most interesting legal issues they've seen in their careers and what they are seeing on the horizon, among other topics. Today, we are joined by Dustin Guzior, who co-heads our intellectual property and technology litigation practice. Dustin has an active trial practice across all venues, federal and state courts, U.S. International Trade Commission, the Patent Trial and Appeal Board, and foreign and domestic arbitrations. Dustin has been a partner of Sullivan and Cromwell since 2019. From my perspective, I sort of always think of you at heart as not so much an IP lawyer, but a trial lawyer. I wonder how you think about your own career.
I think about it the same way. My practice really is 50-50 classic intellectual property, patents, trade secrets, but then 50% what I would consider complex contract disputes, typically for tech or biotech or medical technology focused companies, where it really has nothing to do with a patent or a trade secret. And it's much more about the business logic underpinning a contract, for example. And I think that really is an advantage in my practice because I'm not constantly thinking about these very narrow, sort of picayune patent issues. I have a much better perspective on what the business problems are. And I think I have a much better handle on how to help our clients.
What is your favorite thing to do as a litigator?
My favorite thing to do as a litigator is to try cases.
I knew you were going to say that.
Yeah, so we're developing a practice where we're brought in as, I like to call it, triage counsel, 4 to 5 weeks before a jury trial is going to start, or we're brought in after there's been some thermonuclear verdict. Just 3 weeks ago, I was in Wilmington, Delaware, where we were brought in as triage counsel on the defense side for a patent trial. We ended up getting a defense verdict for our client, which was really rewarding. It was just such a rush to learn the case that quickly and to really step in a meaningful way. So I love that stuff. I like coming in and doing the post-verdict motions, and I think we'll continue to develop the practice in that area.
It's really so wonderful to be a litigator who has both the ability to work on sort of day-to-day and cutting edge issues, but also gets to stand up in court. And you really have had such an interesting career. What are some of the most interesting issues you've worked on or cases and trials?
So first, let me do the nerdy part, and then I'll do the business part. In IP, I'm really interested in how our clients protect software inventions. So much of what our clients do and what they build is software based. And I think that's only going to increase in the future. Like we interact virtually, right? It's zeros and ones at the end of the day running through a machine. So I've done some really interesting work on how you claim software inventions, how you defend against and enforce them, and then how you assess damages. And my favorite issue that I've worked on recently is something that I'll be arguing in the federal circuit next year, which focuses on US patent damages for software sales to customers abroad, where the distribution system is set up in the United States. Now, the non-nerdy side, the business side is, I love working on complex contract disputes for tech and biotech clients because I'm fascinated by what I call the ambiguity that gets the deal done. A blockbuster 10-figure contract dispute almost always arises because of 3 to 4 words in a contract where both sides saw the ambiguity, but they knew that they had to live with it in order to get the deal done. And I love arguing those interpretation issues because I'm fascinated by the psychology of negotiation.
You were made co-head of the intellectual property and technology litigation practice pretty early on in your partnership. What has been your primary focus in this area?
So my focus has been on growing the practice, particularly becoming known as trial lawyers for these really difficult technology cases. That work includes recruiting and building a team of technically trained lawyers and other generalist litigators who want to speak the science of our client's business. And as I said, we've been developing a reputation for trial work in tech and biotech, either where we're hired from the beginning of the case or where we take over as the case approaches trial.
Are there any high-level legal developments in this area that you think clients need to be particularly alert to?
Yeah, watch the pending legislation. There's a bill called PARA and a bill called Prevail. PARA is about the type of things that can be patented in the United States. And PARA would be a sea change in this area that would dramatically change patent law overnight. Prevail is more focused on the procedure for where and how the validity of patents are challenged. It's not quite the same sea change, but it's going to be really important to understand those changes in the law if Prevail passes.
Switching topics a little bit, as I know you are well aware, S&C generally raises its litigators to be generalists and having a sort of multidisciplinary approach to the practice. You have developed sort of an interesting niche. How does the S&C generalist approach weave into your practice?
Well, the generalist model is awesome because I am always doing something that I love, regardless of the subject matter. Our tech clients come to trust us as general trial counsel. And for example, for a client called Signify, formerly Philips Lighting, where we've done patent work, we were pulled in as post-verdict triage counsel after they got hit with a 9-figure common law negligence jury verdict. It came out of nowhere and it hit them. They liked us as trial lawyers. They liked the way we thought strategically. And they asked us if we would pretty please come in and help them with the post-verdict motions, where we got a $60 million remitter from a hostile trial court judge, where we've handled the case going up on appeal and we'll have a decision soon. So I think the generalist model makes us stronger lawyers. We aren't siloed into particular subject matter areas. I think it makes the lawyers at S&C second to none.
You've had such amazing successes really early on in your career, and you have clients who come back to you and who recommend you. What would you say is the most important part of working with clients to develop these kinds of strong and productive relationships?
You have to understand a client's business goals. And I think most importantly, you have to empathize with the challenges faced by your client contacts. For the GC, maybe that's questions from the CEO. For the CEO, maybe that's questions from the board. It's really important not to myopically focus on a narrow legal issue. You want the client to feel like you've got a problem covered from all angles. When you caucus in those minutes before you walk into the board meeting or you step into the first day of the trial.
I will risk a last question for you, and I can't help but ask, but any great trial stories that you can share?
There's one that always comes to mind. We were on the defense side of a patent trial in the International Trade Commission, and we had a great inequitable conduct defense, which basically is that the claimant or the plaintiff procured their patent through fraud on the patent office. And I was very, very close to our client on the defense side. I felt very strongly about our case. And the plaintiff's or the claimant's patent prosecution counsel was compelled to testify live at the trial. And he was a 52-year-old Norwegian man, a patent lawyer in the United States and Norway. And during my cross-examination of him, I made him cry, which was a tremendous achievement, both because I think the other side deserved it royally and because, as I said earlier, I find human psychology, especially in the negotiation or in the trial setting, to be fascinating. And that's a win that I'll always carry with me. And we ended up winning the full defense post-trial decision on the basis that that witness was testifying about.
That's wonderful. I also have a making someone cry story, but I'll save it for a different podcast. Dustin, it's always so much fun to talk to you, really, and you have such great and interesting insights. Thank you for taking the time to share them.
It's always a pleasure to talk with you, Sharon. Thank you very much.